I'm sorry, we do need to take up one matter outside the presence of the jurors. If they're ready, it will take a few moments. Apologies. Okay, we are going to go on the record on case CR 22211623, State of Idaho versus Chad Guy Daybell. We began a special sentencing proceeding under Idaho's death penalty statute yesterday. At the conclusion of the return of a verdict in this case, the court gave some preliminary instruction to the jurors. They convened for the evening. We're starting again with that hearing today on this special sentencing proceeding. The court has been advised by defense counsel of an intent to potentially not present mitigation, and I have in a closed sealed hearing inquired with counsel on a proffer to cover that. However, I also want to go through and determine whether or not there's a knowing and voluntary waiver of that right on the record and do that outside the presence of the jurors. So, Mr. Daybell, let me just outline your rights here for you briefly. In this special sentencing proceeding, you do have the right to both present mitigation and also a right of allocution that can be exercised at the conclusion of the proceeding before the jury deliberates. There are a couple of instructions that would be provided to the jurors. I'll read an instruction called mitigation, and it reads as follows. A mitigating factor is any fact or circumstance relating to the crime or to the defendant's state of mind or condition at the time of the crime or to his character, background, or record that tends to suggest that a sentence other than death should be imposed. A mitigating factor does not have to constitute a defense, excuse, or justification for the crime, nor does it even have to reduce the degree of the defendant's blame for the crime. My instructions given at the end of the trial phase that you are not to allow sympathy for the defendant to enter your deliberations do not apply at this sentencing phase. Mitigating factors may include any fact or circumstance that inspires sympathy, compassion, or mercy for the defendant. Evidence supporting the existence of a mitigating factor may come from the trial phase or this sentencing phase, whether produced by the defendant or the state. One other instruction that will be given is the defendant's right to allocution, and that reads, the defendant has the right to personally address you. This is called the right of allocution. Allocution is not made under oath and not subject to cross-examination. The law provides that these statements are something that the defendant is allowed to present to you as mitigation. You may consider these statements in your deliberations. So, Mr. Pryor, I've discussed this with you on the record already, but you have explained the right of mitigation and allocution to your client. Is that correct?
I have, Your Honor.
All right, Mr. Daybell, the purpose of these rights is to potentially present evidence to the jury that could result in them finding that the death penalty should not be imposed in your case. Do you understand that?
I do.
All right, and I'm also advised then that you do not intend to, despite the preparation of mitigation from your attorney, you don't intend to present that evidence at this hearing. Is that your choice?
That is my choice.
Has anyone coerced or pressured you personally to make that choice?
No.
And do you feel like you're thinking clearly this morning as you make that choice?
Yes.
Okay, well, that is your right, Mr. Daybell. So thank you for putting that on the record for the court before we brought the jurors in. At this time, then, we are going to proceed with the remainder of this special sentencing proceeding, and we'll have the jurors brought into the courtroom, please.
What's up, everybody? So, of course, something like this would happen while I'm away, but that's okay. Chad Daybell has waived his right to present mitigation evidence. What does that mean? Well, you've just watched the clip. You heard it from his own mouth. He is waiving the opportunity to talk to the jury and give them reasons not to give him the death penalty. Even after he's been convicted, he pled not guilty. He said he didn't do it. He maintained his innocence. He pointed the finger at Lori Vallow. He pointed the finger at Alex Cox. He pointed the finger at Warwick and Gibb. But now that he's been convicted, it seems like he's ready to take his medicine. It seems like, and really the only reason I can think a criminal defendant would ever do this, or I've ever heard of a criminal defendant doing this in this situation, is that he wants the death penalty. He does not want life in prison. There can be a lot of reasons for that, and every individual can have their different reasons for that. But in this situation, there's really no other positive reason why Chad Daybell would do something like this. it also eliminates and waives potential appellate issues through this sentencing phase and through this sentencing portion of the trial. So he's not going to be able to make certain arguments he may have made if he presented mitigation evidence at this phase. So I'm sure you guys are going to have a lot of questions. I'll try to get to them, but I wanted to at least get this explanation out to you as quick as I could. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.